there's all kinds of strategy, and strategy is very important in anything in law, particularly in whistleblower claims. And then there's just flat out winning. And I am very pleased to announce that on August 29th, 2019, we won a United States Court of Appeals for the First Circuit appeal. And it was in a whistleblower case. The name of the case is Jason Mount versus United States Department of Homeland Security. This was yet another case against ICE. And the board of winnings against ICE continues. Mr. Mount is a dear man. He and his wife both. He's been a client here for a number of years, and I am very pleased for him, and I am pleased that this will change the way these cases are litigated, and that I had the ability to actually affect the law. And I'm going to get into, in this podcast, how this Mount decision ties into the previous podcast where we went through what happens at an MSPB hearing, and it's very important, and what clients and potential clients or prospective clients should do now that the decision in Mount versus the United States Department of Homeland Security number 18-1762 has been issued. So let me first recap the previous whistleblower, what happens at an MSPB whistleblower hearing podcast. And we talked about there were 3 elements that had to be proven, 2 by the federal employee and 1 by the federal government. So the first was the actual whistleblower disclosure, that the appellant, the federal employee, had to show that he had a good faith belief, he or she had a good faith belief that he or she was trying to actually solve a problem, and that the person's disclosure was in writing, we said, is pretty much a necessary element. That was very important. We talked about the definitions of what counts as a whistleblower disclosure, and you can review those on the previous podcast. Second, we talked about the contributing factor, that the knowledge and timing test, which basically says that the adverse action, if it is followed within about a year or so of when the disclosure was made by the people about the disclosure or who read the disclosure, that will be enough for the appellant to satisfy that element. And then we talked about the clear and convincing third element, that the government has to prove that it would have taken the same action against the whistleblower anyway, whether he or she disclosed this or not. And they had a high standard of evidence, and we talked about finally how the AJs kind of sort of go out of their way to knock out the first element of whistleblower disclosure so that they don't have to do the rest of the analysis. So what is Mount's case about, and why is it so important? There is a doctrine called the Perceived Whistleblower. Now, what does that mean? That means that if you go back to element 1, even if the federal employee did not actually make a whistleblower disclosure, or, and this case is groundbreaking for a number of reasons, but one of the biggest reasons that it's groundbreaking is, and this was argued by the U.S. attorney who I was up against in Boston on April 1st, 2019. I remember the day distinctly. It was a Monday. And one of her arguments to the panel, and they didn't buy this for a second, was a perceived whistleblower is only covering someone who doesn't make a disclosure, who doesn't make any disclosure. Meaning it doesn't cover someone who made a disclosure, but the disclosure didn't meet the strict elements of illegality or fraud or abuse or something like that. And I argue, judges, that's crazy, because what you're essentially saying, if that were true, is that somebody who didn't blow the whistle at all is in a stronger position than somebody who did. And the judges agreed with me. That can't be the law. So a perceived whistleblower is not only for people who, let's say, there was a misunderstanding where a supervisor believed that someone had made a disclosure to a newspaper but was wrong. No, this covers now somebody like Jason Mount, who the lower court found was not an actual whistleblower, okay, but he did something. He just didn't do something that met a strict definition. In Mount's case, it was he assisted someone else in their whistleblower case. But that doesn't matter, the court says. What's important is, did the supervisors who disciplined Mr. Mount, did they go ahead and believe that he had provided that assistance? And this shows up in many, many cases. That is a big, big holding for whistleblowers all over the United States. Second point, which the courts really bang on, there is an exhaustion requirement. We know that if you're a whistleblower, unless you get fired or you're suspended for more than 15 days, you have to first exhaust your complaint with the Office of Special Counsel. That is this agency, which 99% of the time doesn't do a damn thing to help anybody. But nonetheless, you have to go there. And you have to file a charge. You have to, kind of like the EEOC, you have to write out the whole story. There'll be a lawyer who's going to investigate it. He's going to have some follow-up questions. And at the end of the day, he'll issue something that'll say something. Nothing to see here. And now you have your right to bring your case to the Merit Systems Protection Board within 65 days of that closeout letter. Okay, so the lower court, the administrative judge in Mount's case, dismissed Mount's perceived whistleblower claim. Why did he do that? Because he said that there's a Federal Circuit precedent requiring the employee to inform the special counsel of the precise ground of the whistleblowing charge. And Mount didn't do that. Mount never said, I am officially bringing a perceived whistleblower claim. He never said that. And because he never said that, he did not exhaust a perceived whistleblower complaint claim. And therefore, the MSPB doesn't have jurisdiction over that. Okay, that's foolish. The court, First Circuit Court of Appeals, I mean, real judges. I mean, these are people with the robes, appointed for life, one step down from the Supreme Court of the United States, says in the very second page of this opinion, says, Judge Torella says, we find this to be, we reject the MSPB's hyper-technical application of this exhaustion requirement, and says that forget all that. And he goes through the legislative history of how important it is to protect federal whistleblowers and how the All Review Circuit Act basically has told the federal circuit, you're just letting the government agencies get away with murder here. They say, finally, that this has to do with a notice requirement, okay, and that the notice, by the way, on the OSC form doesn't even say the word, are you a perceived whistleblower claim? That's a point that I made in the oral argument, which was held back in April of 2019. And the court goes on and says that what's important here is that Mount says in his OSC paperwork, he says things that support the core element of a perceived whistleblower claim, that agency officials appeared to believe that he engaged in whistleblowing activity. And therefore, whether he was a messenger, not a messenger, whether he was the FedEx guy, he wasn't the FedEx guy, it doesn't matter. It doesn't matter. That basically it's the perception of the supervisors that counts. And the court goes through similarities, for example, in the EEOC. EEOC, this case comes up a lot. There's someone who sues for religious discrimination, says you treated me differently because you thought I was a Muslim. And the supervisor or the employer says, well, we found out you're not a Muslim, though. You're actually a Christian Arab. So you can't sue for discrimination based on religious discrimination of Islam because you're not a Muslim. No, the courts throw that out. It doesn't go by whether the guy was actually a Muslim or not. It goes by whether you thought he was a Muslim. Same thing here. This goes by were there enough facts in the Office of Special Counsel charge drafted by the client or his or her lawyer to put the agency on notice that this was a claim. And the court says that's the test. Now, why is this important? For a whole lot of reasons. I mean, when I ask why this is important, I mean, like, why is this important for listeners to this podcast? And I think one of the biggest reasons is people listening to this podcast may already have an MSPB case. And they, just like Mr. Mount and others, wouldn't have the foggiest notion that they were supposed to write perceived whistleblower on their charge. It's nowhere on the form. And therefore, they may be litigating MSPB whistleblower claims where the AJs are sitting back. They're waiting for you. They're waiting for your argument. And I'll never forget, I had one of these where, one of the first ones I've done of these, where the AJ, he acts all smugly, like he's really listening to your case and everything. No, he's not doing any of that. He's thinking of ways to knock you out on the first element so he doesn't have to rule on the rest of the case. And that's going to happen to you, okay, unless you retain a lawyer who knows this area. So you don't want to lose your case because of an exhaustion requirement, and you shouldn't on a perceived claim. And pretty much many claims can now be viewed as perceived whistleblower claims than before August 29th, 2019, based on this holding. So if you are in the middle of your MSPB case, or you are in the middle of your OSC filing, or you're in the middle of whatever, and you want representation, contact me, and we'd be happy to look into your case. Thank you.